We will go on the record in the matters 23 CF 172, 24 CF 208, State of Wisconsin versus Joseph Berg. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Berg appearing in person with counsel Daniel Chapman. We're set today in this matter for a sentencing portion of the case. Mr. Berg pled guilty to 1 count of possession of a firearm by a convicted felon and 1 count of felony bail jump. The court ordered a pre-sentence investigation report. The court has reviewed the document. Mr. Schmidt, any material facts or corrections for the record?
I don't have any.
All right, lock in, because this sentencing hearing is way heavier than it looks on paper. We've got Joseph Berg, a convicted felon who pleaded guilty to having a firearm and felony bail jumping, and both sides are already signaling something you don't see every day, a push for probation, not prison. But here's the twist, this case is soaked in grief, substance relapse, and a night that police say turned dangerous fast. So the question is this a story about accountability, or a man unraveling after tragedy?
Where defendant Joseph Berg's daughter died in an accident. 3 months later, Joseph Berg found himself in possession of a rifle, some ammunition, and extremely under the influence of something. As that case has gone on, Mr. Berg picked up a new case in Polk County, which is subsequently resolved. That's what triggered the bail jumping complaint that piggybacked off of the Polk case. That's the second case here today. During the duration of the Polk and Burnett matters, Mr. Berg has been in jail for an extremely long period of time. Taking a holistic approach, looking at all these matters together, at Mr. Berg's history and his personal circumstances in his life, the state has come to the conclusion that the 14 or so months of jail he spent as an initial punishment during that period of time is sufficient. And the court should look to place Mr. Berg on probation for a period of 4 years on the 23 count and 3 years on the 24 count. Between the two of those cases, he would have a great deal of time hanging over his head, minus the 14 months he's already served. Analyzing this from the McCleary-Gallion perspective, I think that's what the court should do. So before getting into the gravity of what the offense is, I want to emphasize something that maybe is a bit back and forth or unclear in the Department of Corrections recitation of the facts. And that is the depiction of Mr. Berg's behavior in the 23 case. It's one of those things where when you read it on paper, it probably sounds a lot worse than it looks when you watch the body cam footage. His behavior was entirely captured on body cam, so it's not really subject to speculation what happened. In that video, Mr. Berg is just, I would describe, completely out of it when the police interact with him. And by that, I mean unresponsive. He's kind of just standing stiff as a board. Police move in and about and around him. He doesn't move. At one point, they use a beanbag gun because they're concerned because of the complaint about the gun and the rifle and the ammunition. They shoot him 3 times with the beanbag gun, doesn't budge a centimeter. And that's a weapon that has a great deal of force. It causes a great deal amount of pain. You could see the injuries afterwards, no response. So at the time, whatever he was under the influence of, he was.
I just want to stop you right there. Is that what they meant by less lethal shotgun?
Yes.
That was confusing. So
I mean, it's like a shotgun that fires beanbags.
I only know of it as a beanbag gun. So.
Yeah, so that's what they're talking about. It hurts a lot. I don't think I can say more than that on it. And seeing no reaction from him, shine a light in his face, no pupil reaction, that's what the.
Here's where defense strategy kicks into high gear. They're not denying the guilty pleas. What they're doing is shaping the story for sentencing. Notice the focus: invited over, pre-existing relationship, no indication the gun was fired, barely coherent, and most importantly, questioning the reliability of the other person's account. That's a classic sentencing move: reduce perceived threat, raise context, and argue rehabilitation over punishment. But let me ask you, when someone's intoxicated around a firearm, does context change the danger, or is that the danger?
Olson, it was coming out of this drug-induced stupor in this situation. The reason I wanted to emphasize that is, the term resisting or obstructing can have a lot of different meanings. It can encompass someone, I'm not being arrested, I'm going to fight, I'm going to hit you back and punch you in the face. It can encompass, I think the court hears sometimes of someone pulling away, and then it can encompass situations like this where a person is just incapable of really responding because of something they're under the influence of. In Wisconsin, when you're talking about voluntary intoxication, that can't even be talked as like a defense to criminal liability, but it's absolutely something that should be considered at sentencing in terms of figuring out what exactly this like obstructive or resistive behavior was. Because I know when I read the PSI's recitation of it, and even the way it comes off in the police reports, which form the criminal complaint, it might come off as something else. I wanted to be clear about that so the court understands why the state and why the DOC came to the conclusion of probation given what was written before. So I think that also sheds a major light on what probably is the worst part of this incident, what is the nexus or the cause of it, which is a form of substance abuse. The PSI details a history of substance abuse in it. It's actually pretty lengthy. It also documents multiple times in which the defendant actually did treatment and actually even completed treatment paradigms. It's been a while since he's done one last. He had a significant long period of sobriety that occurred up until his daughter passed away, which was a couple months before the initial incident. So I think when I read the PSI, what I'm reading is that I think DOC is rightly and correctly identifying that this one event in Mr. Berg's life, the passing of his daughter, was a really transformative one to the negative in his life. It really affected him. I think it would be improper to assume it's a coincidence that 23 CF 172 happens so soon after that. If you accept that premise, which I think the court should, a person with substance abuse issues relapsing hard after their toddler age child passes away, it affects the McCleary-Gallion analysis quite a bit. It tips the analysis heavily into the rehabilitative potential category. We know he has a substance abuse issue. It's long-term. We know he successfully completed treatment. We know he's achieved long-term sobriety in the past. Therefore, we have good reason to believe that therapy in conjunction with grief counseling and substance abuse refresher might change Mr. Berg's behavior to get it back before 23 CF 172. The nature of that trauma, it being a long-term trauma that lasts, shows the best way to protect the public would be a long-term plan that contemplates the substance abuse, the mental health, the grief, as opposed to maybe a medium or a short-term thing like a jail sentence or a prison sentence. Those would be a short-term solution to a long-term problem. So the best way to achieve the purposes is to plan a long-term solution with this longer form of probation. I think that the gravity of the offense, it is large. It is. It's still use of controlled substances. It's still in the presence of a firearm. It's still involved in an officer being hurt. That's why he pled to the offenses he did and why there will be so much hanging over his head while he's on probation. I think with the amount of probation was hanging over his head and the enormous amount of pre-sentence credit, I think the seriousness of the offense is not depreciated. And I think in total, what this would be if the court followed the DOC's recommendation and followed the state's recommendation, this would be the best way to achieve all of the purposes of McCleary-Gallion, of the best odds of protecting the community in the future by rehabilitating Mr. Berg and not depreciating the seriousness of the offense. The 14 months jail is what did that. The longer term of probation is what's doing that. The big sword in terms of the withheld sentence do that. Thank you.
What is the jail credit?
I counted 431 days. I have the dates if anyone wants them.
All right, thank you. All right, Mr. Chapman.
Your Honor, I'm not sure if you're actually aware of the circumstances as to how Mr. Berg's daughter died, but it was actually an in-home accident.
I'm very aware, and
I won't go into detail then.
it's It's more than just a passing of a child.
Yes.
It's more than just having a daughter die. It is extremely, extremely traumatic, the incident that occurred.
Yes, Judge. And then I will not belabor the point, but I just wanted to make sure the court was aware of that if you were not. And I agree, based on the PSI, based on Mr. Berg and his mother's statements, I think that's all, if not excusable, definitely understandable that a person, despite being sober for 4 years, would relapse under circumstances like that. And he did just go off the deep end. In addition to the state's description of the body camera video, I would also point out, I really don't think that the depiction of events based on victim one's recitation of things is entirely reliable. I think it is incredibly likely that Mr. Berg was invited over to the cabin that night. These two have a pre-existing relationship. She's the mother of 2 of his children. I don't believe that a person would just be driving past with a motorcycle to scare her and then decide to sit at a bonfire calmly. I think the two were using drugs together. And she admitted to that, although she says he forced the drugs down her throat. And her explanation actually never encompassed when or how he was in the cabin, but his stuff was apparently found in there. I just don't think she's a reliable witness. That doesn't really change anything regarding the underlying facts, but it does change the tone of the circumstances that night. Mr. Berg was on the video approximately 6 or 8 feet away from where the gun was sitting. His DNA was found on the magazine, although not on the other parts of the gun, and there was no indication that it was actually fired that night. He didn't reach for it. He didn't threaten anyone with it when the police were there, although obviously he was barely coherent at the time the police were there. I think the most important factor in the PSI's recommendation here, Judge, is simply the fact that since he's been sentenced in Polk County, he's been on probation and he's been fully compliant. Since July 10th, he's been out of custody. He's been on probation. He's been doing everything they've asked. There's been no violations, and he's been attending Alcoholics and Narcotics Anonymous classes. He's been sober. I think the fact that he is showing right now that he's in the community staying sober is the best argument that can be made that that path should be continued in the near future. Definitely a lot hanging over his head. Definitely if he messes up, he's facing a lot of time. But I think that is probably the department's primary consideration as to why probation is appropriate, is because he is showing that he's an appropriate candidate for probation. Also, he spent 431 days in custody, and if he were given a confinement sentence, a large portion of that would be eaten up right up front. If the court imposes and stays conditional jail time, that would not even necessarily involve the credit. And if the court wants to impose a prison sentence, I believe that could also be appropriate in this case.
This moment matters more than people realize. When the court documents say a less lethal shotgun, that can sound like something out of an action movie, so the clarification is key. They're talking about bin bag rounds, meant to stop someone without using deadly force. And the scary part isn't the label, it's the fact he allegedly didn't react at all. In sentencing, that feeds the judge's risk analysis. Was he intentionally resisting, or was he so impaired he wasn't even present? And viewers, does that make it more sympathetic, or more dangerous?
With probation, and he's been mending his relationship with his wife and children. I agree with both the state and the PSI recommendation here, Judge, that the proper thing to do to protect the public is to place him on probation for a long period of time. 3 or 4 years is appropriate. Whether it's an imposed in state prison or a withheld sentence, either way, we all know he's looking at a significant prison sentence if he does not follow through with what he appears to be doing now. And if he stays sober, I believe the public will be protected.
Mr. Berg, do you care to make any statement here today? It's your only opportunity to let me know anything you want me to know, or to correct anything that may have been said not as accurately.
I guess I'd just like to apologize for my behavior at the time. My daughter passing is not really an excuse. It just kind of happened that way, I guess. I'm sorry. That's it.
Thank you, Mr. Berg. You were just in Polk County not too long ago when you got sentenced, and I mean, you've been sentenced before, so you have an understanding of what a court must look at when they sentence an individual. First and foremost is the nature and the gravity of the offense. How serious is this case? Second, I have to look at you, your criminal history, your education, those types of things. And then third, I have to look at the community, protecting the public. This is very serious, but as Mr. Schmidt stated, that on black and white and how it first comes to this court and how it is to this court, unless I have motion hearings to be able to hear specific facts of a case or through arguments at sentencing, all I get is the black and white. And in the black and white, it looks extremely scary, and it looks extremely serious. Mr. Schmidt did correct that and say, based upon the body camera footage, that it's less scary than what I read in the black and white. Because you can't make that up. Body camera is body camera, and it shows what happened. And Mr. Schmidt said that for the most part, your behavior was caught on, and it was on the body camera. But again, even if it's less serious than the black and white, it's still serious. You were, as Mr. Schmidt or as the PSI stated, you were kind of in a catatonic state. You weren't responding to anything. Your pupils were not making any reaction. You were shot with the less lethal beanbag shotgun 3 times, and it pretty much didn't do anything to you. You didn't even flinch. So that shows that you were in this state where you truly had no idea what you were doing. But again, as you said, there's no excuse for your behavior. You put yourself in that position. You put on your shoes, you put on your pants, you did those things, and you were in that area. I have to look at your criminal history. You've been to prison. You do have, I wouldn't say an extensive criminal history, but you do have a long criminal history with some serious convictions. The Polk County matter, I'm going to tell you, that was scary too. Hearing the incident that occurred in Polk County shortly after release from this county, but you were still in that grief. You're never, ever going to get over the passing of your daughter. I lost a daughter. I know the feeling. I didn't lose a daughter in as traumatic of a way. I am so sorry for your loss, for your wife's loss, for your family's loss.
Thank you.
No one can even have the words to make it better. You will never, ever get over it. It just gets easier. It's been 12 years for me. And I understand that, so I guess I'm going to say I kind of understand where you were and that you just lost it. I don't understand to that extent because I've not been addicted to substances, but I do understand the desperation and the inability to be able to really want to control yourself and your behavior. But again, you're the one who's responsible for you and your behavior and what happens and transpires. And that's why we have you here today for sentencing. I do commend you for working at Chipotle. Hopefully you get a free meal. I used to work at Subway. You get a free meal, and that's the best part of the job. But you're doing what you need to do to support your family, to remain sober, and that's the number one. How many days have you been sober?
Since I got arrested, September 7th.
Well, I'm very glad to hear that. And that's in 2023?
2024.
2024, from the Polk County matter.
Yes.
That's a significant amount of time. And it's a struggle each and every day. It's not easy for you, even though it's been a significant amount of time. It's still not easy. I know this. I have people that I work with in treatment court. You have to choose every day to be sober, and you're making the right choices. And you are the one who made the choice to be in control of your life and not have the substances control you. And that's a positive. I have to look at needing to protect the public, and here it also does include your ex-girlfriend, because She is a victim of this. I have to look at the public as a whole, because you let yourself get into this situation and be under the influence of all of the things that you were under the influence of, and in a position where your mind couldn't control your body. And so something more serious and devastating could have happened. I do think that probation is appropriate. What I'm going to do is I'm ordering 3 years of probation for both counts. You did sit a significant amount of time in custody. That was needed. I think that was necessary for you. It was for you to get grounded, and it was for you to probably have the realization that you do not want to go back to prison. You do not want to leave your children again. You do not want to leave your wife. You worked very hard to get back to that relationship. And it's, again, a struggle with the loss and the significant loss of a child. I'm going to say you have 431 days of jail credit if you are revoked. I'm not doing a withheld sentence. I'm just from my review of the PSI, you're on a withheld sentence in Polk County. So I'm going to do an imposed but stayed sentence, 2.5 years for each count concurrent to each other. Okay. And quite honestly, I'm going to let Polk County determine if you are revoked and you do go back to be sentenced. I'm hoping you're not, but if you are, I'm going to let them determine and decide whether or not they think it should be consecutive to my sentence or concurrent to my sentence, but my counts are concurrent. Okay. 2.5 initial confinement. Yes. And then extended supervision will be 2 years. Okay. So 2.5 in if you're revoked and 2 out if you're revoked. I'm betting that you're not going to be revoked. You're going to use your daughter's memory and where you are now to continue to build your life and your future. While you're on probation, absolute sobriety. No use or possession of any illegal drugs, substances, or paraphernalia. No alcohol. No bars, taverns, liquor stores, or establishments that have the primary purpose for the sale or the service of alcohol. And Chipotle's, I know some of them serve beer and maybe wine or something like that. That's excluded. So okay. They don't primarily serve. Regular testing from your agent. You're continuing therapy?
I haven't recently. Don't have the insurance for it right now. This is what happened, basically.
Okay, and you're not able to get on any type of state-funded insurance?
No, I make like $800 over that or something.
That's a shame. All right. I'm going to look at all the other recommendations that the Department of Corrections, if they've asked for anything different. No contact with anyone who is known or suspected to be involved in the use, manufacturing, or trafficking of mood-altering substances, illegal substances. I am also going to order the moral recognition therapy, and that'll be working with your agent to determine when and where that will come into your probation. Any probation that DOC requests, no contact with the victim or residents, except as it relates to, I don't know if there is a restraining order, but no contact unless it relates to facilitating placement for your children. And any modification of the no contact can be with DOC authority. So they may talk to her, and maybe there comes a time when you can have contact, but I'm leaving that up to DOC. Okay. I think that covers everything. With regards to fines and fees, I think you have significant amounts posted. shouldn't be any restitution, correct?
Correct.
No restitution. I'm gonna order $500 per count. That says inclusive of any fines, fees, surcharges. Oh, sorry, I was thinking misdemeanor. No, so it would be $600 per count. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. You must report to probation immediately. I know you're on probation in Polk County, but you still have to, when you're done here, go to probation. I think they may close at 4 o'clock, so I'll give you until noon, or I'll say 4 tomorrow to contact probation. You may even be able to just call them because they're going to transfer your probation to Polk County anyway.
Okay.
Because you live, or do you? No, you don't. You live in St. Croix County.
I technically live in Pierce, but I'm on probation in St. Croix.
Okay, so you may be able to just call and they'll transfer it to St. Croix County to your probation there. But again, until 4 tomorrow, let's make sure that I have your address correct. Greenwood Valley Drive.
Yep.
And telephone ends in 8330.
Yep.
Why don't, before you even leave the building, you at least call probation and see if you need to make an appearance.
Okay.
Because I want to make sure that they know that I've sent you there and that you're not going to miss it. Again, 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I need your DNA. You're going to need to make sure that the Gwinnett County Sheriff's Department has your DNA. If they do, you don't have to give it again. But if they do, if they don't have it, you have to get a swab. In this matter, I don't think you would be able to have your DNA expunged because of the felon in possession of firearm charge, but you can still request it through a written letter to the Department of Justice if you wish to do so. Mr. Schmidt, what am I missing?
Nothing from me.
Mr. Chapman,
Nothing else. Thank you.
good luck. Mr. Berg, keep working on yourself, and I know you're going to because you don't want to let your daughter down.
Thank you, Your Honor.
And condolences to you and to
So here's the final outcome. Joseph Berg is sentenced with 3 years of probation on both counts, and the judge chooses an imposed but stayed prison sentence, meaning if probation is violated, the confinement and supervision time becomes very real, very fast. The court emphasizes public safety, sobriety, no alcohol environments, testing, treatment requirements, and no contact boundaries, because the legal system is balancing two truths at once. Grief can explain a spiral, but it can't excuse the risk created that night. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. 5.